En gros, on est sur entre 35 et 40 millions d'euros. Et c'est pas aussi facile que ça. Mais il faut que parce que sinon on est sur une Nous avons été le premier lac en eau douce à avoir l'agrément des normes affluents propres et en biodiversité. Vous voyez, c'est quand même assez puissant. Et là, si vous voulez, eh bien, cet été, nous avons connu ça. Il y a 1150 bateaux sur le lac de Sarconson, 750 anneaux publics. Et il a fallu que j'en réquisitionne 5 de mise à l'eau installées. Et puis, l'état des plages pour les reconditionner, pour que les plages soient vraiment praticable, même si un fort nage, bien évidemment que cela se fera d'ici dans une année.
Donc là, ça paraît impressionnant, mais en réalité, on est bien mieux qu'en passé.
Ah oui.
Et donc là, on a normalement,
là, c'est normal.
Ça va fondre,
voilà.
C'est normal. Là,
Voilà,
c'est normal.
Et tu vas avoir 17 mètres de haut de plus quand ça fond. Donc tu vas retrouver
17
déjà
mètres de fond dans les écrins où il a encore neigé énormément le week-end dernier.
Côte 761 et 17 mètres de marge avec l'enneigement.
Donc là, on est beaucoup mieux qu'en passé.
Ah oui. Nous avons 10 mètres de plus. 10 mètres de plus que l'année dernière. Donc on peut dire que c'est quand même...
Et naturellement, on a tiré même déjà
Allez, oui, Esther, on reste ensemble.
La saison d'hiver, les gens vont de manière individuelle sur l'exploitation, c'est moins packagé que pendant l'hiver. Voilà. C'est la saison d'hiver, qui est on dit que tout va mal. Toutes nos stations étaient pleines cet hiver. Dans les 5 dernières années, c'est la meilleure saison. Quand même, hein.
Refuse de rediscuter des contrats qui sont signés sous leur pression, sous la contrainte de la dernière de novembre. C'est aujourd'hui le prix de l'énergie. Tant mieux, EDF ne veut pas reprendre ça et signer de nouveaux contrats.
En novembre, il y a eu du chantage, c'est-à-dire qu'on leur a proposé de ne pas en décembre, sinon ils
parce qu'il y avait une peur de devoir fermer.
Oui,
et donc c'est les consommatrices en raison des activités
ils ont fait signer des contrats à 10 fois le prix, et ces communes-là, ils se sont retrouvés à devoir signer ces contrats à cette époque-là, sont
signer des contrats
au
prix marginal.
Vous en avez combien sur le département?
Une. 85. Mais l'année
dévolue, je sais pas.
Dévolue, il y avait les ors, les 12,
et Marso. Non, les ors.
saison. En plus, ils se sont adaptés sur les heures d'ouverture, sur la vitesse, sur le fonctionnement. Donc, j'ai ça dans plusieurs tout, mais enfin, on fait une très belle saison. Et l'été dernier, malgré tout, avec un peu moins d'eau, on fait quand même une belle saison. Tous nos jeux, tous nos bars, tous nos cafés, tous nos restaurants sont pleins. Alors, bien sûr, il y a quelque chose à traiter. Et au niveau de l'eau, avec le préfet régional, on a fait un super travail. Il n'y aura pas de guerre d'hiver ici. Il n'y aura pas de guerre d'hiver ici. On a anticipé, on met des moyens. On a l'expérience en fait, en réalité. Il n'y a jamais eu d'eau chez nous. Attends, s'ils ont fait ça.
C'est important, c'est Victor de le dire aussi.
Non, mais tout à fait,
le sénateur,
tout
là,
à fait, tout à fait. Non, mais
Il est sur la délégation.
Il est en forme depuis ce matin, il nous a dit j'attends, monsieur le
C'est la
président.
pluie. Ça fait déjà plusieurs jours, avant même que la
Patience. Oui, très bien.
Il y a un
Non,
sujet
non, mais-
d'entretenir, ça retrouve souvent sur du bénévolat. Et donc là aussi, il y a un problème de gouvernement.
Bien sûr.
Mutualiser, parce qu'ils ont un rôle important dans l'organisation, notamment
Mais-
sur
La discussion qu'on a
Mais-
avec le préfet et le président du département tout à l'heure, en fait, la taille des Alsaces dans l'histoire.
Bien sûr, c'est ça.
En revanche, sur les prélèvements en eau, on a réglé le problème par un décret de
Et le regroupement est spontané ou c'est...
Le préfet.
Vous l'accompagnez, monsieur.
Et nous, c'est bien pour vous. La canalisation, on a dit, on doit être canalisé.
Alors en fait, bon, tu te mets derrière ça?
Non, je me mets sur le côté.
Non, parce que là, c'est là que le président est.
Oui, oui, non, mais je vais me mettre sur le côté du président.
Totalement
114.
114. Bon.
Sur les 170 communes qui ont plus de 50%. Reste après. On a 114 qui gèrent l'eau de
On voit
manière.
bien que- Est-ce que c'est un vrai problème la fuite dans ces communes-là?
Ah bah oui, bah, tu vois,
Pour ça, président, non mais
c'est
que dans les 114,
Très bien.
Et puis on arrive à mettre...
fait un débat.
Sujet essentiel de la réunion des élus.
Faites passer ce message, monsieur le président. Vous ne serez pas venu pour rien dans les Hautes-Alpes, au moins sur ce sujet.
C'est bien.
On avait dit ça. Philippe début
Qui veulent encore parler de la réforme des retraites. Est-ce que pour vous, le débat est clos ou c'est quelque chose dont vous souhaitez encore parler avec eux peut-être?
Non, il y a une manifestation, je crois, de 200 personnes environ qui sont ici, ce qui est normal, parce qu'on sait qu'il y a une contestation et qu'il y a une opposition. C'est d'ailleurs pour ça aussi que la Première ministre recevra l'intersyndicale la semaine prochaine. Et donc il y a des mobilisations qui sont là, qui sont dans un cadre prévu par notre démocratie. Il y a un dialogue qui se poursuit. Il y a aussi des échéances, on le sait, pour que le chemin démocratique de ce texte aille jusqu'à son terme. Moi, je suis là aujourd'hui pour avancer sur un sujet qui est essentiel et qui fait aussi la vie de beaucoup de nos communes et de nos compatriotes sur tout le territoire. Et je suis très heureux de retrouver ce beau département qui est celui de l'eau et du rapport à la sécheresse. On a tous vécu l'été dernier une situation qui était absolument terrible. J'avais parlé moi-même de la fin de l'abondance en revenant de cet été. On a eu des communes à un niveau inédit et surtout dans une répartition à travers tout le territoire qui ont été confrontés à ce problème de l'eau. Et donc il y a eu un très gros travail fait par les élus, le gouvernement, les experts. Et là on vient le parachever, si je puis dire, en annonçant cette stratégie qui va nous permettre de préparer l'été prochain et surtout les années à venir. Il y a un immense travail.
Monsieur le Président, est-ce que ce déplacement sur le thème de l'eau, c'est un moyen pour vous d'essayer de passer à autre chose alors qu'il y a une crise politique dans le pays?
Non, il y a une contestation sociale qui existe sur une réforme, mais ça ne veut pas dire que tout doit s'arrêter. Et c'est normal, on continue à travailler. Parce qu'il se trouve qu'il y a toujours des problèmes d'inflation, on doit continuer à réduire le chômage dans notre pays, on doit répondre aux problèmes de sécheresse, on doit préparer la saison à venir, on doit faire face aux sujets alimentaires. On a la géopolitique qui continue, donc c'est normal. Je fais mon travail.
C'est pas une crise politique selon vous, ce qu'on traverse en ce moment dans le pays?
Écoutez, j'ai le sentiment qu'il y a eu un moment de clarification politique qui a donné lieu à un vote à l'Assemblée nationale. Après qu'il y ait des commentaires, c'est une chose, mais ça a été clarifié au moment du vote sur la motion de censure. Maintenant, il y a un texte qui est devant le Conseil constitutionnel et il doit l'examiner avec la sagesse qui va avec cette institution et le calme qui sied à ces débats.
Mais est-ce que vous entendez les manifestants?
Bien sûr, il y a 200 manifestants. Mais est-ce que ça veut pour autant dire que la République doit s'arrêter et qu'on doit dire on doit attendre de revenir sur les sujets de sécheresse dans un mois? La réponse est non. On doit continuer de travailler avec beaucoup de respect, de calme. J'ai donné un mandat à la Première ministre, c'est ce qu'elle fait, elle est en train de travailler avec les groupes politiques, avec tout le monde. Mais il est normal qu'on continue de travailler avec les élus, avec les habitants sur des sujets aussi essentiels que l'eau.
Mais pour être très clair, la question des 64 ans, vous ne reviendrez pas dessus, sauf si le Conseil constitutionnel décidait de censurer le texte.
Mais je ne vais pas redire la même chose tous les 4 jours. Sinon on bégaye. Non, elle ne m'empêche pas ni d'aller à la rencontre des Français, ni d'aller sur le territoire. Et j'ai eu l'occasion de le dire, il y a eu des scènes d'une violence inacceptable ces dernières semaines. Celle-ci, je les condamne avec la plus grande fermeté. Il y a une instrumentalisation politique qui a parfois poussé ou légitimé cette violence, qui a refusé de la condamner. Je veux ici redire tout mon soutien à l'égard des élus, qu'ils soient parlementaires, maires, élus de la République, qui ont parfois été agressés en raison des positions qu'ils avaient tenues. C'est incompatible avec une démocratie. Et redire mon soutien à nos forces de l'ordre. Mais à côté de ça, que les forces syndicales s'expriment dans un contexte où il y a une réforme, de manière organisée, parfois sonore, mais enfin respectueuse, c'est normal, c'est la démocratie. Et c'est prévu par notre Constitution. Et je dois dire que nos syndicats ont tenu des manifestations, des mobilisations qui se sont faites dans pour eux, le calme et le respect. Voilà.
Monsieur le Président, lors de votre interview télévisée, quelques jours après 49.3, vous avez fait preuve d'une fermeté qui, on l'a entendu dans les manifestations, a poussé beaucoup de gens à se mobiliser. On a vu d'ailleurs le lendemain un regain de mobilisation dans la rue. Est-ce que d'une certaine manière, amende honorable aujourd'hui, vous dites j'ai eu un ton peut-être trop ferme qui a pu crisper des gens.
Mais je ne suis pas le commentateur de moi-même. C'est votre travail, c'est pas le mien. Donc sincèrement, on doit avancer. Notre pays, d'abord, a des forces extraordinaires. On parlait là de la vitalité économique de nos stations de montagne, des bons résultats qu'on peut avoir. Il y a des choses qui vont bien dans le pays, il faut aussi savoir le dire, le regarder en face. On est un des pays qui résiste le mieux face au choc de l'inflation. On a une économie qui continue d'être forte, qui doit continuer de se réindustrialiser. On est en train de tous se retrousser les manches pour notre école, notre santé. On fait la transition écologique. Donc on a des chantiers immenses. Donc quand je dois parler, je parle, je m'exprime, j'essaie de répondre aux questions des journalistes, mais après je ne vais pas 8 jours après commenter ce que je dis. Voilà.
Peut-être un mot sur ce qui s'est passé à Sainte-Soline, parce qu'il y a eu des blessés aussi bien du côté des manifestants que des forces de l'ordre. Vous avez sûrement observé cela. Il y a aussi une polémique sur l'accès des ambulances.
Qui je crois a été levée par le SAMU lui-même, cette polémique. Non, je vais vous dire, il s'agit justement d'un projet qui correspond aux critères que nous évoquions tout à l'heure. On en a besoin pour justement avancer sur les questions d'eau. Il faut le faire avec des concertations. Elles ont eu lieu avec beaucoup de respect pour les parties prenantes. Et c'est aussi pour ça que je remercie tous nos élus de mener ce travail. Bon. Qu'il y ait des contestations, c'est une chose. Rien ne peut justifier la violence. Il y a des gens qui venaient contester et qui étaient là en famille, qui d'ailleurs, à Mel, le lendemain, ont tenu un moment plus festif qui n'a donné lieu à aucun débordement. Mais vous avez des milliers de gens qui étaient simplement venus pour faire la guerre. C'est inacceptable. Et donc je réaffirme mon soutien aux élus et aux forces de l'ordre. Et nos forces de l'ordre, avec beaucoup de courage, ont avancé. Et ça montre bien qu'il y a chez certains une forme d'habitude de la violence qui s'installe. Il faut la combattre avec beaucoup de fermeté. Et je demande à toutes les forces politiques républicaines d'être parfaitement claires sur ce sujet. Il n'y a rien qui justifie la violence dans une société démocratique.
Comment apaiser cette situation ?
Mais c'est en appelant chacun déjà à la responsabilité, vous savez. C'est une bonne chose, parce que quand on est élu de la République, on a une responsabilité. On peut s'opposer à des projets. Dans ces cas-là, on va essayer de convaincre les électeurs pour avoir une majorité s'y opposer. Mais on ne justifie pas, parce qu'à ce moment-là, si on se met à dire quelque chose qui me déplaît légitime, une violence, on aura tous des violences légitimes. Et ça redevient l'état de nature. C'est pas ça une démocratie, encore moins une république.
Merci beaucoup. Pourquoi vous n'avez pas fait de déplacement en région pendant ces 2 mois ?
J'essaie de faire des déplacements au maximum. J'ai eu aussi beaucoup de contraintes internationales. Dès la semaine prochaine, je serai à nouveau en Chine puis aux Pays-Bas. Donc j'alterne la vie nationale et la vie internationale. Et les déplacements ces dernières semaines aussi ont été contraints d'une part par mon agenda international et d'autre part, à la fois déplacements en Afrique ou en Europe, et d'autre part par le fait qu'il y avait aussi un calendrier législatif. Mais je suis là devant vous aujourd'hui.
Merci. Il a choisi la plus belle région d'Europe pour que la distribution de l'eau reste équitable au niveau du lac de Serpenson.
Alors d'abord, je veux saluer ici le modèle, qui est un modèle de concertation permanente et qui permet justement, entre les élus, avec les associations, de beaucoup pacifier les choses. Et c'est un modèle historique, avec une une infrastructure qui est elle aussi historique dans cette zone. Et je veux saluer vraiment le travail qui a été fait ces dernières années, celui qui est en train d'être fait. On en parlait avec le maire, le président du conseil régional, du conseil départemental et les parlementaires, qui me rend très confiant sur l'avenir. Et c'est aussi pour ça que dans le plan que le ministre a préparé, qu'on va présenter dans ses grands axes et qu'il développera ensuite, il y a un geste de confiance à l'égard des territoires. C'est que c'est au plus près du terrain qu'on peut gérer justement la répartition des usages. Et les règles dépendent de l'existant, de la culture de coopération ou pas, de la manière dont tout ça s'est structuré. Et donc nous aimons l'égalité, nous devons avoir des grands plans nationaux parce qu'il y a énormément d'investissements à faire, mais on doit accepter la différenciation et la flexibilité locale. Merci beaucoup.
Merci.
Attention à votre cahier, je ne suis pas du tout. Pardon. Bon courage.
Ramasse les restes de l'AFP.
Chez moi, il y a 10 degrés de moins. Ce matin, il disait moins 2.
C'est vrai?
Oui, mais dans le sud.
On arrête. S'il te plaît. J'habite le Grand Nord.
Veuillez vous asseoir.
Please sit down.
La Cour se réunit aujourd'hui conformément.
The court is meeting today pursuant to Article 58 of its statute and 94 of its rules to read out in open court its judgment in the case of certain Iranian assets, Islamic Republic of Iran versus United States of America.
Pour des raisons de,
For reasons explained to me, Judge Robinson, who has duly participated in the deliberations and in the final vote in this case, is unable to sit with us this afternoon.
Je rappelle que
I will recall that the proceedings in the present case were instituted on the 14th of February 2016 by the Islamic Republic of Iran against the United States of America with regard to a dispute concerning the alleged violations by the United States of the Treaty of Amity, Economic Relations and Consular Rights, which were signed by the two states in Tehran on the 15th of August 1955 and entered into force on the 16th of June 1957, to which I shall hereinafter refer as the Treaty of Amity or Treaty. On the 1st of May 2017, the United States raised the preliminary objections to the jurisdiction of the court and the admissibility of the application. In its judgment of the 13th of February 2019, which I shall call afterwards 2019 judgment, the court found that it had jurisdiction to attend and rule on the application filed by Iran with the except with respect to Iran's claims based on the alleged violation of rules of international law on sovereign immunities. As for the preliminary objection regarding its jurisdiction to entertain Iran's claims of proposed violations of Articles 3, 4, or 5 of the Treaty of Amity, predicated on the treaty accorded to Bank Markazi, the Central Bank of Iran, the court found that the objection did not possess an exclusively preliminary nature. The court also found that Iran's application was admissible. In accordance with the usual practice, I shall not read out the introductory paragraphs of the judgment, which set out in the main elements in the procedural history of the case. I shall also omit some paragraphs and summarize others. I will therefore begin reading the judgment at paragraph 21. The full text of the judgment will, of course, be available at the close of this sitting. The court recalls that on the 15th of August 1955, the parties signed the Treaty of Amity, which entered into force on the 16th of June 1957. Iran and the United States ceased diplomatic relations in 1980 following the Iranian Revolution in early 1979. And the seizure
It's right? It's okay, it works?
Doesn't work.
No? I think that
there seem to be no problems as far as we're concerned. Some judges are not receiving the English translation.
ask someone to look for the technical part. So, can you tell me, is the translation back?
The translation is working, I think. Yes? Judge Chouet. You have to speak in French. Ah, you have to speak in French. I see. To find out whether the interpretation into English is working or not. Can you hear, Judge Chouet?
Working. The system is not working. I'm sorry.
The system is not working.
This is the English book speaking. Can you tell us if you can hear us? We are trying on a different console. Apparently now the system is working. If we could signal to the President that the system is working.
J'ai l'impression.
I have the feeling that the parties are hearing the interpretation. Is that correct? And it's only some of the judges on the bench who are having problems hearing the interpretation. But I will continue into French so that the judges may follow the text in both languages.
En octobre,
in October 1983, the United States Marine Corps barracks in Beirut, Lebanon, was bombed, killing 241 United States service members who were part of a multinational peacekeeping force. The United States claims that Iran is responsible for this bombing and for the subsequent acts of terrorism and violations of international law, including the bombing in 1996 of a housing complex in Saudi Arabia known as the Khobar Towers, which killed 19 United States service members. Iran rejects these allegations. In 1984, in accordance with its domestic law, the United States designated Iran as a, and I quote, state sponsor of terrorism, end of quote, a designation which it has maintained ever since. In 1996, the United States amended its Foreign Sovereign Immunities Act to which I shall hereinafter refer as the FCIA, so as to remove the immunity from suit before its courts of states designated as state sponsors of terrorism in certain cases involving allegations of torture, extrajudicial killing, aircraft sabotage, hostage-taking, or the provision of material support for such acts. It also provided exceptions to immunity from execution applicable in such cases. Plaintiffs then began to bring actions against Iran before United States courts for damages arising from deaths and injuries caused by acts allegedly supported, including financially by Iran. These actions gave rise to the Peterson case concerning the bombing of the United States barracks in Beirut, among other cases concerning alleged acts of terrorism. Iran declined to appear in these lawsuits on the ground that the United States legislation was in violation of the international law on state immunities. In 2002, the United States enacted the Terrorism Risk Insurance, to which I shall hereinafter refer as TRIA, which permitted certain enforcement measures for judgments entered pursuant to the 1996 amendment to the FSIA. In 2008, the United States further amended the FSIA, enlarging the categories of assets available for the satisfaction of judgment creditors. In particular, to include all property of state-owned entities of those states having been designated state sponsors of terrorism, whether or not that property had previously been blocked by the United States government. In 2012, the President of the United States issued Executive Order 13599, which blocked all assets of the government of Iran, including those of Bank Markazi and other Iranian financial institutions, where such assets are within United States territory or within the possession or control of any United States person, including any foreign branch. And that was a quotation. Also in 2012, the United States adopted the Iran Threat Reduction and Syria Human Rights Act, Section 502 of which, inter alia, made the assets of Bank Markazi subject to execution in order to satisfy debts under default judgments against Iran in the Peterson case. Bank Markazi challenged the validity of this provision before United States courts. The United States Supreme Court ultimately upheld its constitutionality. Following the legislative and executive measures taken by the United States, many default judgments and substantial damages judgments have been entered by United States courts against the state of Iran, and in some cases against Iranian state-owned entities. Further, the assets of Iran and certain Iranian entities, including Bank Markazi, are now subject to enforcement proceedings in various cases in the United States or abroad, or have already been distributed to judgment creditors. On the 14th of June 2016, Iran instituted the current proceedings before the court, arguing that as a result of the United States executive, legislative, and judicial acts, Iran and Iranian entities were suffering serious and ongoing harm. By diplomatic note, dated October 3rd, 2018, addressed by the United States Department of State to the Ministry of Foreign Affairs of Iran, the United States, in accordance with Article 23, Paragraph 3 of the Treaty of Amity, gave in writing 1 year's written notice of the termination of the treaty. The court begins by examining questions of jurisdiction and admissibility. It recalls that one of the preliminary objections raised by the United States sought to have the court dismiss as outside its jurisdiction all claims of purported violations of Articles 3, 4, or 5 of the Treaty of Amity that are predicated on treatment accorded to the government of Iran or Bank Markazi. The court recalls that in its 2019 judgment, it had considered that it did not have the elements necessary to determine whether Bank Markazi was carrying out, at the relevant time, activities of a nature which permit the characterization of an entity as a company. Since those elements were largely of a factual nature and linked to the merits of the case, the court had concluded that it could rule on the objection to jurisdiction at issue, and I quote, only after the parties had presented their arguments in the following stage of the proceedings, end of quote. The court, following the line of reasoning it adopted in its 2019 judgment, is thus now called upon to determine whether the evidence presented to it by Iran throughout the entire proceedings, and at the merits stage in particular, shows that Bank Markazi was carrying out, at the relevant time, activities which could be categorized as commercial and which would therefore permit the bank to be characterized as a company within the meaning of the treaty. Regardless of whether or not those activities, should they be established, constituted its principal activities. Before taking its analysis any further, the court emphasizes that to answer the question above, it is not required to rule on the international law on immunities. First, it recalls that in its 2019 judgment, in upholding the second preliminary objection to jurisdiction raised by the United States, it declared that, and I quote, insofar as Iran's claims concern the alleged violation of rules of international law on sovereign immunities, end of quote, in particular, to the detriment of Bank Markazi. And the court does not have the jurisdiction to consider them. Further, it notes that in order to rule on the question whether the activities of Bank Markazi presented by Iran as being of a commercial nature permit the bank to be characterized as a company within the meaning of the treaty, it is not required to ascertain whether the entity in question could claim, with regard to those activities, immunity from jurisdiction or enforcement under customary international law. These are two separate questions. The rules on sovereign immunities are those laid down by the Treaty of Amity concerning the treatment of companies are two distinct sets of rules. In particular, the questions whether under customary international law a state enjoys immunity from jurisdiction in proceedings relating to a commercial transaction, and if so, which criteria should be applied to determine whether a transaction is commercial, need not be addressed by the court for the purpose of examining the objection to jurisdiction at issue. The court will thus confine itself at present to ascertaining whether Iran has established that Bank Markazi was carrying out at the relevant time activities of a nature such that the bank should be characterized as a company for the purposes of the Treaty of Amity. The court notes in this regard that the only activities on which Iran relies to found the characterization of Bank Markazi as a company consists in the purchase between 2002 and 2007 of 22 security entitlements in dematerialized bonds issued on the United States financial market and in the management of proceeds deriving from those entitlements. In the opinion of the court, these operations are not sufficient to establish that Bank Markazi was engaged at the relevant time in activities of a commercial character. Indeed, the operations in question were carried out within the framework and for the purposes of Bank Markazi's principal activity, from which they are inseparable. They are merely a way of exercising its sovereign functions as a central bank and not commercial activities performed by Bank Markazi. Alongside sovereign functions, to use the words of the 2019 judgment. The court thus concludes that Bank Markazi cannot be characterized as a company within the meaning of the Treaty of Amity. Consequently, the objection to jurisdiction raised by the United States with regard to Iran's claims relating to the alleged violations of Articles 3, 4, and 5 of the Treaty of Amity, predicated on treatment accorded to Bank Markazi, must be upheld. The court has no jurisdiction to consider those claims. The court next examines the United States objection to admissibility based on an alleged failure to exhaust local remedies. The court recalls that under customary international law, when a state brings an international claim on behalf of one or more of its nationals on the basis of diplomatic protection, local remedies must be exhausted before the claim may be examined. In this case, the court does not consider that it is required to rule on the question of whether Iran's application was submitted preponderantly in defense of its own rights or to protect those of Iranian companies, assuming that criterion to be relevant. Indeed, for the reasons set out hereafter, the court is persuaded that the companies in question did not have any effective means of redress in the legal system of the United States that they failed to pursue. Under customary international law, the requirement that local remedies be exhausted is deemed to be satisfied when there are no available local remedies providing the injured persons with a reasonable possibility of obtaining redress. What characterizes the United States measures complained of by Iran in the present case is that they were established by legislative means or by executive acts based on legislation, and that they were given effect by court decisions applying federal legislative provisions. It appears from those decisions that each time an Iranian entity sought to have a federal legislative provision set aside by a court on the ground that it ran counter to the rights enjoyed by that entity under the Treaty of Amity, the court, after finding that the provision at issue was not contrary to the treaty, referred to the jurisprudence whereby courts are, in any event, obliged to apply the federal statute when it was enacted after the treaty. The Iranian companies that succeeded in having certain measures set aside by the courts were only able to do so by demonstrating either that the contested measures fell outside the scope of the statute on which they were said to be founded, or that they were contrary to the statute itself. The effectiveness of local remedies must be assessed in light of the rights claimed by those concerned. In this case, the rights guaranteed to Iranian companies by the Treaty of Amity. Given the combination of the legislative character of the contested measures and the primacy accorded to a more recent federal statute over the treaty in the jurisprudence of the United States, it appears to the court that, in the circumstances of the present case, the companies in question had no reasonable possibility of successfully asserting their rights in United States court proceedings. The court is not, by the above finding, making any judgment upon the judicial system of the United States or on the distribution of powers between the legislative and judicial branches under United States law as regards the fulfillment of international obligations within the domestic legal system. For the foregoing reasons, the court concludes that the objection to admissibility based on the failure to exhaust local remedies cannot be upheld.
The court next deals with the defences on the merits put forward by the United States. With respect to the United States defence based on the clean hands doctrine, it observes that although invoked in international disputes, the argument based on clean hands doctrine has only rarely been upheld by the bodies before which it has been raised. The court itself has never held that this doctrine in question was part of customary international law or constituted a general principle of law. As a defense on the merits, the court has always treated invocation of unclean hands with the utmost caution. It notes, moreover, that the ILC has declined to include the clean hands doctrine amid the circumstances precluding wrongfulness in its articles on the responsibility of states for internationally wrongful acts. To which I will refer hereinafter as the ILC articles on state responsibility. On the ground that this doctrine, and I quote, has been invoked principally in the context of admissibility of claims before international courts and tribunals, though rarely applied, end of quote. In any event, in the view of the respondent itself, at least several conditions would have to be met for the clean hands doctrine to be applicable in a given case. Two of these conditions are that a wrong or misconduct has been committed by the applicant or on its behalf, and there is, quote, a nexus between the wrong or misconduct and the claims being made by the applicant state, end of quote. In the view of the court, there is not a sufficient connection between the wrongful conduct imputed to Iran by the United States and the claims of Iran. For the above reasons, the defense on the merits based on the clean hands doctrine cannot be upheld. The court then turns to the means of defense raised by the United States based on the abuse of rights. In this regard, the court notes that by arguing that Iran is committing an abuse of rights by seeking to apply the Treaty of Amity to measures which are unrelated to commerce, The United States is merely asserting, in another way, that Iran's claims fall outside of the scope ratione materiae of the treaty. This question was addressed by the court in terms of its jurisdiction in the 2019 judgment. It will be referred to in terms of the merits in the following section of this judgment as part of the examination of Iran's claims based on the alleged violation of provisions of that treaty. The court can only accept the abuse of rights defense in this instance if it were demonstrated by the respondent on the basis of compelling evidence that the applicant seeks to exercise rights conferred upon it by the Treaty of Amity for purposes other than those for which the rights at issue were established, and that it was so doing to the detriment of the respondent. The court therefore considers that the United States has failed to make such a demonstration. Consequently, the defense based on an alleged abuse of rights cannot be upheld. The court next examines the defenses raised by the United States on the basis of Article 20, paragraph 1c and d of the Treaty of Amity. With respect to Article 20, paragraph 1c, relating to the production of or traffic in arms, the court cannot accept the United States' broad interpretation of the provision concerned. The terms of Article 20, paragraph 1c, taken in their ordinary meaning and in the light of the object and purpose of the treaty, cannot bring within its scope any measures other than those which are intended by a treaty party to regulate its own production of or its own traffic in arms, or to regulate the export of arms to the other party or the import of arms from the other party. In the view of the court, Article 20, paragraph 1c cannot be relied upon to justify measures taken by a party which might impair the rights afforded by the treaty and which are solely intended to have an indirect effect upon the production of and the arms traffic by the other party or in the territory of the other party. There is nothing in Executive Order 13599 which meets the criteria defined in the previous paragraph. As a result, the United States defense based on Article 20, paragraph 1c of the Treaty of Amity cannot be upheld. With respect to paragraph 20, paragraph 1d, Article 20, paragraph 1d of concerning measures necessary to protect the essential security interests, the court is of the view that it was for the United States to show that Executive Order 13599 was a measure necessary to protect its essential security interests. and that it has not convincingly demonstrated that this was so. Even accepting that the respondent enjoys a certain margin of discretion, the court cannot content itself with the latter's assertions. It further notes that the reasons set out by the executive order to justify the specific measures it enacts relate to the financial practices of Iranian banks, deficiencies in Iran's anti-money laundering system, and the ensuing risks for the financial system taken as a whole. There is no mention of security considerations. Therefore, the court concludes that the defense based on Article 20, paragraph 1d of the treaty cannot be upheld. I will now pursue the reading of the judgment.
Violation by the United States of its obligation under the Treaty of Amity. The claims of Iran concern a set of legislative, executive, and judicial measures adopted by the United States since 2002. These measures include Section 201A of 3A and Section 1610G, 1 of the FCIA, as well as the application of those provisions by the United States courts. The judicial decision of which Iran complains were rendered by United States courts in application of those legislative provisions. They ordered the attachment, execution, turnover, or distribution of assets of certain Iranian companies. Iran's claims also concerns Executive Order 13599 of 2012, which is entitled Blocking Property of the Government of Iran and Iranian Financial Institutions. The parties agree that as concerns the domestic cases challenged by Iran in these proceedings, the main effect of executive order was the blocking of Bank Markazi's assets. Since the court has found that it does not have jurisdiction under the Treaty of Amity to entertain claims relating to alleged violations of Articles 3, 4, and 5, predicated on treatment accorded to Bank Markazi, it will not consider Iran claims in respect of Executive Order 13599 insofar as they concern this entity. For the same reason, the court will not consider Iran's allegations with respect to the Peterson case and Section 502 of the Iran Threat Reduction and Syria Human Rights Act. The court will, however, examine Iran's other claims in respect of Executive Order 13599. The court observes that the parties have divergent views on the question to what extent the Treaty of Amity imposes limits on a state's regulatory powers. In this respect, the parties' disagreements essentially relate to the alleged disregard of the separate legal personality of Iranian companies and to the attachment and execution of their assets to satisfy liability judgment against Iran. Their main arguments on this issue concerns the interpretation of Article 3, Paragraph 1 and Article 4, Paragraph 1 of the treaty and their application in the circumstances of the present case. Since the parties' arguments in respect of those provisions are closely related, the Court will address Iran's claims based on Article 3, Paragraph 1 and Article 4, Paragraph 1 together before examining the remainder of its claims. The Court begins by examining the scope of the obligation established by the first sentence of Article 3, Paragraph 1 of the treaty, which provides that, I quote, companies constituted under the applicable laws and regulations of either high contracting party shall have their judicial status recognized within the territories of the other high contracting party. End of quotation. The parties' disagreement revolves around the meaning of the phrase shall have their juridical status recognized. The Court considers that the expression juridical status refers to the company's own legal personality. The recognition of a company's own legal personality entails the legal existence of the company as an entity that is distinct from other natural or legal persons, including states. It does not follow, however, that the legal situation of such an entity will always be the same as in the state in which it was constituted. In the present case, it is not disputed that the companies allegedly affected by the measures of the United States were constituted under Iranian law as a separate legal entities with their own legal personality. The parties disagree on whether the United States disregarded the legal personality of the companies through its legislative, executive, and judicial measures, and whether this was justified. In the Court's view, the obligation under Article 3, Paragraph 1, to recognize the juridical status of companies of the other contracting party is not necessarily satisfied by the fact of their appearance at and participation in domestic judicial proceedings. The Court will examine all the relevant measures in order to determine whether the United States disregarded the legal personality of the Iranian companies, and if so, whether this was justified. The Court will address these questions in the context of its examination of Iran's claims under Article 4, Paragraph 1 of the Treaty of Amity. The first clause of Article 4, Paragraph 1 provides that, I quote, each high contracting party shall at all times accord fair and equitable treatment to nationals and companies of the other high contracting party and to their property and enterprises. End of quotation. The parties agree that the obligation to afford fair and equitable treatment includes protection against the denial of justice. In the present case, the right of Iranian companies to appear before the courts in the United States, to make legal submissions and to lodge appeals have not been curtailed. The enactment of legislative provisions removing legal defenses based on separate legal personality and their application by the courts do not in themselves constitute a serious failure in the administration of justice amounting to the denial of justice. The second clause of Article 4, paragraph 1 provides that, I quote, each high contracting party shall refrain from applying unreasonable or discriminatory measures that would impair the legally acquired rights and interests of nationals and companies of the high contracting party. End of quotation. Even though the first and second clauses of Article 4, paragraph 1 lay down two separate obligations, there is an overlap between the protection against unreasonable or discriminatory measures stipulated in the second clause and the broader standard of fair and equitable treatment provided for in the first clause, because fair and equitable treatment can encompass protection against unreasonable or discriminatory measures. The Court considers that the terms unreasonable or discriminatory in the second clause of Article 4, paragraph 1 reflect two different standards against which the conduct of a state may be separately assessed. The Court begins by examining whether the measures taken by the United States and challenged by Iran are unreasonable. In its ordinary meaning, the term unreasonable means lacking in justification based on rational grounds. In the Court's view, a measure is unreasonable within the meaning of the Treaty of Amity if it does not meet certain conditions. First, a measure is unreasonable if it does not pursue a legitimate public purpose. In the present case, the United States contends that the legislative provisions challenged by Iran, as well as the judicial decisions that applied these provisions, had the purpose of providing compensation to victims of terrorist acts for which Iran has been found liable by the United States courts. As a general rule, providing effective remedies to plaintiffs who have been awarded damages can constitute a legitimate public purpose. In addition, a measure is unreasonable if there is no appropriate relationship between the purpose pursued and the measure adopted. The attachment and execution of false assets of a defendant that had been found liable by domestic courts can generally be considered as having an appropriate relationship with the purpose of providing compensation to plaintiffs. Furthermore, a measure is unreasonable if its adverse impact is manifestly excessive in relation to the purpose pursued. In the present case, Section 201A of TRIA and Section 1610G1 of the FCIA employ very broad terms which are capable of encompassing any legal entity, regardless of Iran's type of degree of control over them. In addition, by dispensing with the requirement the relevant assets were previously blocked, Section 106.10G1 ensures that any assets of those legal entities are available for attachment and execution. Thus, by design, these legislative measures plainly disregard the Iranian company's own legal personality, making it possible to impair their legally acquired rights and interests, namely those related to their ownership or interest in the assets liable to attachment and execution. Section 201A of TRIA and Section 1610G1 of the FCAA have been applied by the United States courts in several enforcement proceedings involving Iranian companies. The court observes that in the circumstances of the present case, the Iranian company's own legal personality has been set aside in relation to liability judgments rendered in cases in which those companies could not participate and in relation to facts in which those companies do not appear to have been involved. The court considers that disregarding the legal entity in such circumstances is not justified. In light of the foregoing, the court considers that even assuming that the legislative provisions adopted by the United States and their application by the United States courts pursued a legitimate public purpose, they caused an impairment of the Iranian company's rights that was manifestly excessive when measured against the protection afforded to the purpose involved. The court therefore concludes that the legislative and judicial measures were unreasonable in violation of the obligation under Article 4, Paragraph 1 of the Treaty of Amity. With respect to Executive Order 13599, the Court recalls that this executive measure blocked all property and interests in property of Iran and Iranian financial institutions, failing within its preview, because Executive Order 13599 encompasses, I quote, all property and interests in property of any Iranian financial institution, end of quotation. It is manifestly excessive in relation to the purpose pursued. Accordingly, the Court concludes that Executive Order 13599 is also an unreasonable measure in violation of the obligation under Article 4, Paragraph 1. Since the Court has concluded that the measures adopted by the United States are unreasonable, it is not necessary to examine separately whether they are discriminatory. Neither is it necessary to consider the other ground on which Iran has relied to claim breaches of Article 4, Paragraph 1 by the United States. On the basis of its finding that the measures taken by the United States were unreasonable, the Court concluded that the United States has violated its obligation under Article 4, Paragraph 1 of the Treaty of Amity. In reaching this conclusion, the Court has determined that the measures of the United States disregarded the Iranian company's own legal personality, and that this was not justified. In light of all the foregoing, the court also concludes that the United States has violated its obligation to recognize the juridical status of Iranian companies under Article 3, Paragraph 1. The court then turns to Article 3, Paragraph 2 of the Treaty of Amity, which provides that nationals and companies of either high contracting parties shall have freedom of access to the courts of justice and administrative agencies within the territories of the other high contracting party. In its 2019 judgment, the court referred to Article 3, Paragraph 2 of the Treaty of Amity in the following terms, I quote, "The provision at issue does not seek to guarantee the substantive or even the procedural rights that the company of one contracting party might intend to pursue before the courts of authorities or authorities of another party, but only to protect the possibility for such a company to have access to those courts or authorities with the view of pursuing the substantive or procedural rights it claims to have." End of quotation. The court made this statement while addressing Iran's arguments on sovereign immunities. However, the court assessment of Article 3, Paragraph 2 has a broader reach. There is a clear distinction between, on the one hand, freedom of access to the courts with the view of the assertion of rights, and the other, the consent of the substantive or procedural rights that may, the content of the substantive or procedural rights that may be invoked before the courts. In the circumstances of the present case, the rights of Iranian companies to appear before United States courts, make legal submissions, lodge appeals were not curtailed. Iran claims with respect to Article 3, Paragraph 2 are concerned with the rights that Iran companies pursued before United States courts and with their likelihood of success. The application by the United States courts of legislation that was unfavorable to the Iranian companies, and the fact that the companies' arguments on the basis of the Treaty of Amity were unsuccessful are matters related to the companies' substantive rights. These matters do not call into question the freedom of access enjoyed by the companies or the aim of prompt and impartial justice within the meaning of Article 3, Paragraph 2 of the Treaty of Amity. For these reasons, the Court concludes that Iran has not established a violation by the United States of its obligation under Article 3, Paragraph 2 of the Treaty of Amity. The Court then examines Article 4, Paragraph 2 of the Treaty of Amity. It first examines Iran's claim with the respect to the part of that provision concerned with taking or expropriations. The Court recalls that it is not disputed by the parties that United States courts, in application of Section 201A of TRIA and Section 1610G1 of the FCA, subjected to attachment and execution the property and the interests in property of Iranian companies. It is also uncontroversial that the assets were turned over or distributed to plaintiffs who had succeeded in cases before United States courts in which Iran was found liable. Nor is it disputed that the Iranian companies concerned did not receive any payment. Iran has identified property and its interests in property which were affected in the context of several enforcement proceedings before United States courts. The United States has not contested the identification of those assets. The court must determine whether the attachment and execution of the property and interests in property identified by Iran constitute takings contrary to Article 4, Paragraph 2 of the treaty. The court considers that a judicial decision ordering the attachment and execution of property of interest in property does not per se constitute a taking or expropriation of that property. A specific element of illegality related to that decision is required to turn it into a compensable expropriation. Such an element of illegality is present in certain situations when a deprivation of property results from a denial of justice, or when a judicial organ applies legislative or executive measures that infringe international law and thereby causes a deprivation of property. Therefore, in order to determine whether there exists a specific element of illegality, it is necessary to examine the legislative, executive, and judicial acts adopted by the United States as a whole. The court has already concluded that in the circumstances of the present case, Section 201A of TRIA and Section 1610G1 of the FCA, as well as their application by the United States courts, were unreasonable measures in violation of obligation under Article 4, Paragraph 1 of the Treaty of Amity. Reasonableness is one of the considerations that limit the exercise of the governmental powers in this respect. It follows from this element of the unreasonableness, which is found in the legislative provisions and which extends to their judicial enforcement, that measures adopted by the United States did not constitute a lawful exercise of regulatory powers and amounted to compensable expropriation. For these reasons, the Court concludes that the application of Section 201A of TRIA and Section 1610G1 of the ACIA by United States courts amounted to taking without compensation of the property and interests in property of Iranian companies as identified above in violation of the obligation under Article 4, Paragraph 2 of the treaty. The situation with respect to Executive Order 13599 is different. Iran has failed to identify the property or interests in property of Iranian companies that were specifically affected by Executive Order 13599. Indeed, it has accepted that the main effect of Executive Order 13599, as concerns the cases challenged in this proceeding, was the blocking of Bank Markazi assets, which is outside the court jurisdiction. Accordingly, the court concludes that in respect to Executive Order 13599, Iran has not substantiated its allegations in relation to taking under Article 4, Paragraph 2 of the treaty. The court turns now to Iran claims in relation to the obligation to afford the most constant protection and security under Article 4, Paragraph 2 of the treaty. The court considers that the core of the obligation to afford the most constant protection and security under the Treaty of Amity concerns the protection of property from physical harm. In the present case, Iran does not assert that the United States has failed to protect the property of Iranian nationals and companies from physical harm. It argues that the United States has violated its obligation under Article 4, Paragraph 2 to afford the most constant protection and security to the property of Iranian companies, because that obligation also includes the legal protection of property. Accordingly, the court concludes that Iran has not established a violation by the United States of its obligation under Article 4, Paragraph 2, as concerns the most constant protection and security. Based on its finding with respect to the measures of the United States, the court concludes that the United States has violated its obligation under Article 4, Paragraph 2 of the Treaty of Amity, as concerns the prohibition of taking except for a public purpose and with the prompt payment of just compensation. The court then turns to Article 5, Paragraph 1 of the Treaty of Amity. The court considers that the language of the first sentence of Article 5, Paragraph 1 establishes rights for the nationals and companies of the contracting parties to lease property for their residence or for the conduct of their commercial activities, to purchase or otherwise acquire personal property and to dispose of property. The rights established in the first sentence do not entail an absolute obligation for the contracting parties. The contracting parties can exercise their regulatory powers in respect of such acts of lease, acquisition, or disposal of property. The court notes that Iran's allegation with respect to the right of Iranian companies to dispose of property under Article 5, Paragraph 1 are predicated on the same set of facts as its claims in relation to Article 4, Paragraph 2. The court has already concluded that the measures of the United States amounted to taking without compensation in violation of its obligation are under Article 4, Paragraph 2. The court considers that Article 5, Paragraph 1 was not meant to apply to situations amounting to expropriation which are addressed in Article 4, Paragraph 2. As concerns Executive Order 13599, the court notes that the property and interests in property blocked by this executive order may not be transferred, paid, exported, withdrawn, or otherwise dealt in. These terms reflect a general prohibition of the disposal of property. The court recalls, however, that Iran has failed to identify the property or interests in property of Iranian companies that were specifically affected by the executive order other than the assets of Bank Markazi. Indeed, all the other property allegedly blocked by executive order that Iran has brought to the court's attention was blocked by other executive measures which have not been challenged in these proceedings. Such property was therefore not affected by the Executive Order 13599. In light of the foregoing, the Court concludes that Iran has not established a violation by the United States of the right to dispose of property under Article 5, Paragraph 1 of the Treaty of Amity. The Court next examines Article 7, Paragraph 1 of the Treaty of Amity, which states that, I quote, neither high contracting party shall apply restrictions on the making of payments, remittances, and other transfers of funds to or from the territories of the other high contracting party. End of quotation. The parties' disagreement on the interpretation of Article 7, Paragraph 1 concerns the scope of the first part of the provision, in particular the term restrictions. The Court observes that the interpretation of this provision suggested by Iran would give the provision the character of a prohibition of any restriction on the movement of capital. Given the treaty practice of states regarding movement of capital more generally, it is difficult to conceive that the parties intended to impose such a general prohibition, especially in the absence of any words making clear an intention to do so. Accordingly, the Court considers that Article 7, Paragraph 1 is concerned with exchange restrictions. Since Iran claims regarding Article 7, Paragraph 1 are not related to exchange restrictions, they should be dismissed. The Court concludes that Iran has not established a violation by the United States of its obligations under Article 7, Paragraph 1 of the Treaty of Amity. The Court then turns to Article 10, Paragraph 1 of the Treaty of Amity, which provides that, I quote, between the territories of the two high contracting parties there shall be freedom of commerce and navigation. End of quotation. In its 2019 judgment, the Court recalled that the word commerce in Article 10, Paragraph 1 of the Treaty of Amity, I quote, refers not just to maritime commerce, but to commercial exchanges in general, and that commercial treaties cover a wide range of matters ancillary to commerce. The Court sees no reason to depart from its previous interpretation of the concept of freedom of commerce in Article 10, Paragraph 1 of the treaty. The parties disagree on whether the Court interpretation of freedom of commerce requires that commerce and ancillary activities related to it are limited to trade in goods. The Court recalls that the object and purpose of the Treaty of Amity is to encourage, I quote, mutually beneficial trade and investments and closer economic intercourse generally, end of quote. The Court thus considers that financial transactions or operations constitute ancillary activities integrally related to commerce. In the court view, activities entirely conducted in the financial sector, such as trade in intangible assets, also constitute commerce protected under Article 10, Paragraph 1 of the treaty. As previously stated by the Court, in accordance with the text of Article 10, Paragraph 1, in order to enjoy its protection, the commerce concerned is to be between the territories of the United States and Iran. In the oil platforms case, the Court examined whether the process of indirect commerce in oil constituted commerce between the territories of the two states for the purpose of the Treaty of Amity. The Court considered that the matter of the successive commercial transactions relating to the oil was determinative. It reached the conclusion that there was no commerce between the territories of the United States and Iran, noting that, I quote, after the completion of the first contract, Iran had no ongoing financial interests in or legal responsibility for the goods transferred. End of quotation. This conclusion was predicated on the nature of successive commercial transactions relating to oil. It does not follow that any form of commerce conducted through intermediaries is not commerce for the purposes of Article 10, Paragraph 1. Indeed, it is in the nature of financial transactions that intermediaries located in various countries are often involved in the operations. The Court recalls that a party claiming a breach by the other party of Article 10, Paragraph 1 must show that, I quote, there was an actual impediment to commerce between the territories of the two high contracting parties. End of quotation. The United States contends that the measures challenged by Iran are indirect legal impediments to which Article 10, Paragraph 1 does not apply, and that in any case Iran has not shown how the measures interfered with commerce. The Court is aware that the strained relationship between the parties has resulted in a progressive reduction of commerce between them. Nonetheless, there is no doubt that at the time when the measures challenged by Iran were adopted by the United States, commercial relations between the parties were still active. There was trade in goods as reported by the United States Census Bureau. There were also instances in which Iranian companies provided services in Iran to United States companies, as shown by the materials related to the contractual debts in the telecommunications industry and in the credit card services sector, as well as a number of financial transactions performed by Iranian companies in the United States banking system. Executive Order 13599 comprehensively blocked the property and interests in property of Iran and Iranian financial institutions. By its own terms, the executive order constitutes an actual impediment to any financial transaction or operation to be conducted by Iran or Iranian financial institutions in the territory of the United States. Pursuant to Section 1610G1 of the FSIA, any assets of any Iranian company in which the state holds any form of interest are subject to attachment and execution, even if they have not previously been blocked. By its own terms, this provision constitutes an actual impediment to the performance of commercial activities by those entities in the territory of the United States. Moreover, the judicial application of Section 1610G1 of the FCIA and Section 201A of TRIA had caused concrete interference with commerce. In the context of its claims under Article 10, Paragraph 1, Iran specifically mentioned the effects of certain enforcement proceedings with respect to assets of the Iranian Ministry of Defense and the Iranian Navy held by Wells Fargo Bank. The court notes that the first allegation concerns a sum deposited by the company Cubic Defense System, which was owed to the Iranian Ministry of Defense as a result of arbitration proceedings relating to a failure fully to perform contractual obligations after the Iranian Revolution in 1979. With respect to the assets of the Iranian Navy, the only information available is that they were held by Wells Fargo Bank as collateral for letter of credit. In the court's view, the materials submitted to it do not demonstrate that the relevant assets were connected to commerce in such a way that the relevant judicial decisions can be considered instances of interference with commerce as a result of the application of TRIA and the FSIA. However, the effects of the enforcement proceedings with respect to contractual debts in the telecommunication industry and in the credit card service sector constitute clear examples of such concrete interference with commerce. In light of the foregoing, the court concludes that the United States has violated its obligations under Article 10, Paragraph 1 of the Treaty of Amity. The court then turns to the remedies requested by Iran, in particular cessation of internationally wrongful acts, compensation and satisfaction. With respect to cessation of international wrongful acts, the court observes that such an obligation exists only if the violated obligation is still in force. In the present case, the condition is not met since the Treaty of Amity is no longer in force. The United States denounced the treaty by giving notification of its denunciation to Iran on 3rd of October 2018, so that the treaty ceased to have effect a year later in accordance with the provision of Article 23, Paragraph 3 thereof. It follows that Iran's request relating to the cessation of internationally wrongful acts must be rejected. With respect to compensation, the court considers that Iran is entitled to compensation for the injury caused by a violation by the United States that have been ascertained by the court. The relevant injury and the amount of compensation may be assessed by the court only in a subsequent phase of the proceedings. If the parties are unable to agree on the amount of compensation due to Iran within 24 months of the date of the present judgment, the court will, at the request of either party, determine the amount due on the basis of further written pleadings limited to this issue. With respect to satisfaction, the court considers that a finding in the present judgment of wrongful acts committed by the United States is sufficient satisfaction for the applicant. In its final submission, Iran also requested that the court rule that the United States shall pay the costs incurred by Iran in the presentation of this case and the defense of its legal rights under the Treaty of Amity. Article 64 of the Statute of the Court provides that unless otherwise decided by the court, each party shall bear its own costs. In the circumstances of this case, the court can see no sufficient reasons to direct the respondent party to bear the costs of the proceedings. I shall now read the operative part of the judgment. For these reasons, the court, 1, by 10 votes to 5, upholds the objection to jurisdiction raised by the United States of America relating to the claims of Islamic Republic of Iran under Article 3, 4, and 5 of the Treaty of Amity, economic relations and consular rights, to the extent that they relate to treatment accorded to Bank Markazi, and accordingly finds that it has no jurisdiction to consider those claims. In favor, Vice President Gevorgian, Acting President, Judges Tomka, Abraham, Shue, Sebutinde, Bandari, Iwasava, Nolte, Charlesworth, Judge ad hoc Barquette. Against, Judge Benuna, Yusuf, Robinson, Salam, Judge ad hoc Mumtaz. By 13 votes to 2, rejects the objection to admissibility raised by the United States of America relating to the failure by Iranian compasses to exhaust local remedies. In favor, Vice President Gevorgian, Acting President, Judges Tomka, Abraham, Benuna, Yusuf, Shue, Bandari, Robinson, Salam, Iwasava, Nolte, Charlesworth, Judge ad hoc Mumtaz. Against, Judge Sebutinde, Judge ad hoc Barquette. By 8 votes to 7, find that the United States of America has violated its obligation under Article 3, Paragraph 1 of the 1955 Treaty of Amity, Economic Relations and Consular Rights. In favor, Vice President Gevorgian, Acting President, Judges Benuna, Yusuf, Shue, Robinson, Salam, Charlesworth, Judge ad hoc Mumtaz. Against, Judges Tomka, Abraham, Sebutinde, Bandari, Iwasava, Nolte, Judge ad hoc Barquette. By 12 votes to 3, finds that the United States of America has violated its obligation under Article 4, Paragraph 1 of 1955 Treaty of Amity, Economic Relations and Consular rights. In favor, Vice President Gevorgian, Acting President, Judges Tomka, Abraham, Benuna, Yusuf, Shue, Robinson, Salam, Ivasava, Nolte, Charles Worth, Judge ad hoc, Momtaz. Against, Judge Sabutinde, Bandari, Judge ad hoc, Barquette. By 11 votes to 4, finds that the United States of America has violated its obligation under Article 4, Paragraph 2 of the 1955 Treaty of Amity, Economic Relations and Consular Rights, namely, that the property of nationals and companies of the contracting parties shall not be taken except for a public person, nor shall it be taken without any prompt payment or just compensation. In favor, President Gevorgian, Acting President, Judges Tomka, Abraham, Benuna, Yusuf, Shue, Robinson, Salam, Vasava, Nolte, Judge ad hoc, Momtaz. Against, Judges Sabutinde, Bandari, Charles Worth, Judge ad hoc, Barquette. By 10 votes to 5, finds that the United States of America has violated its obligation under Article 10, Paragraph 1 of the 1955 Treaty of Amity, Economic Relations and Consular Rights. In favor, Vice President Gevorgian, Acting President, Judges Abraham, Benuna, Yusuf, Shue, Robinson, Salam, Ivasava, Nolte, Judge ad hoc, Momtaz. Against, Judges Tomka, Sebutinde, Bandari, Charles Worth, Judge ad hoc, Barquette. 7. By 13 votes to 2, finds that the United States of America is under obligation to compensate the Islamic Republic of Iran for the injurious consequences of the violation of international obligations referred to in subparagraphs 3 to 6 above. In favor, Vice President Gevorgian, Acting President, Judges Tomka, Abraham, Benuna, Yusuf, Shue, Bandari, Robinson, Salam, Ivasava, Nolte, Charles Worth, Judge ad hoc, Momtaz.